Appropriations Clause. Common Interpretation by Kate Stith. The Constitution places the power of the purse in Congress. No money shall be drawn from the Treasury, but in consequence of appropriations made by law. In specifying the activities on which public funds may be spent, Congress defines and contours of federal power. This requirement of legislative appropriation before public funds are spent is a foundation of our constitutional order. Appropriations and constitutional separation of powers. The Appropriations Clause is not technically a grant for legislative power because, pursuant to the Necessary and Proper Clause, Article 1, Section 8, Clause 1, Congress clearly has the power to specify the objects, amounts, and timing of federal spending, even if there were no Appropriations Clause. If Congress could not limit the executive withdrawing of funds from the treasuries, then the Constitution grants power to Congress to raise taxes, Article 1, Section 8, Clause 1, and to borrow money, Article 1, Section 9, Clause 2, would be for naught, because the executive would be effectively compel taxing and borrowing by spending at will. Rather, the Appropriation Clause creates a legislative duty that Congress exercise control and assume responsibility over the federal fiscal fisc. Congress' power of the purse is the foundation of our constitutional separation powers, a constitutionally mandated check on executive power. The Appropriation Clause would appear to categorically enjoin the President and the federal agencies to spend funds only as appropriated by Congress, even where the President believes that federal spending is urgently needed. Spending in the absence of appropriations is constitutionally prohibited. Of course, where an emergency exists, a president may decide that a principle more fundamental than the Constitutional appropriations requirement justifies spending. For instance, in the outbreak of the Civil War, when the nation sought risk, Lincoln ordered the expenditure of $2 million in federal funds in advance of appropriations. Moreover, despite the categorical imperative of the Appropriation Clause, it would seem that Congress itself is constitutionally obligated to provide funding necessary for the President to undertake executive power, specifically granted in Article 2, to receive ambassadors, act as commander-in-chief, negotiate treaties, grant pardons, and the like. If Congress fails to provide necessary funds, then the grants of power to the President are themselves for naught. Scholars disagree on the extent to which Congress may use appropriation limitation to control the President's exercise of discretion in carrying out his or her duty to execute the law, especially in the area of national security. They all agree that Congress may not, on the guise of exercise of power for the purse, interfere with indispensable executive or judicial functions, nor may the President frustrate the congressional mandates by refusing to spend directed funds. The constitutional processes for resolving such an impasse may well be political. No federal court has ever ordered Congress to appropriate funds for the executive branch or for the judicial branch, whereas the federal courts have exercised authority to direct state official operations in order to effectuate federal constitutional grantees, such as in the school busing desegregation cases. On rare occasions, as in the case Train versus City of New York, 1975, Federal courts have also intervened to see that a president has no authority to withhold funds. Appropriations limits on amount, object, and duration. There are other critical aspects of the appropriation clause. Appropriation is often thought of as the specification of an amount of money. But appropriations is more than a limitation as to how much money may be spent. The appropriations required by the Constitution also must specify the powers, activities, and the purposes, what we may call simply objects, for which the funds may be used. The specification of these objects is sometimes in an Appropriations Act itself, a so-called rider, but more usually is in the non-appropriations legislation establishing federal agencies on continued particular programs, often called authorization acts. Critically, the mere creation of agency or authorization of activity does not by itself permit expenditure of federal funds. Spending requires another kind of authorization, that is, appropriation. Congress has long codified this object requirements, requiring appropriations shall be applied only to the object for which the appropriations were made, except as otherwise provided by law. The latter phrase refers primarily to a variety of statutes that give executive agencies limited authority to reprogram line items within appropriation under certain conditions. This practice does not contravene the appropriation clause, because reprogramming authority effectively expands the object for which the appropriations are made. Another statute codifies the concept that appropriation must be spent within the time period specified by Congress. The Constitution specifically provides that the duration of appropriation for the Army must be limited to 2 years, Article 1, Section 8, Clause 12. When the first Congress, operating funds for federal agencies have usually been appropriated annually, but large capital projects may have longer appropriation durations. Is backdoor spending constitutional? There are a variety of other forms of federal spending authority besides statutes called appropriations. For instance, Congress has often authorized agencies to obligate federal funds which not yet being appropriated. Such obligation authority is necessary because federal agencies subject to annual appropriations often must enter into multi-year contracts. There is no violation of the appropriation clause as long funds are not paid until appropriated. In other statutes, Congress has indefinitely authorized federal agencies to spend treasury funds or specify purposes, taxes, fees, or forfeitures without separate appropriation of such funds. Such backdoor spending, as it is often called, is usually without limitation as to amount or duration of spending, but usually have effective limitations as to object. Payment for interest on national debt has been indefinitely no limitation as to amount, and permanently no limitation as to duration. Appropriated since 1847. Statutory entitlement programs such as Social Security, unemployment payments, and certain agricultural subsidies are likewise usually funded by an indefinite or permanent appropriation in the statute creating the program itself. The Constitution functional appropriations made by law, a legislative check on the executive branch, and hence on the exercise of federal authority, is performed, if at all, and the creation of the entitlement program and by future Congresses in setting the rates and amounts of agency receipts and payments. However, as time Congress has created spending authority, not only without amount or time limitations, but also arguably without effective objects limitations, where, for instance, the agency has broad discretionary authority in some particular policy area. In such circumstances, although spending has been approved by Congress, it is not clear that the functional purposes of the appropriation clause have been met. There is, for instance, an indefinite, permanent appropriation for national intelligence activities, the objects of which are only partially specified in federal statutes. One questionable form of spending authority is open-ended authority to receive and spend donations and gifts, even gifts conditioned for a particular purpose, which Congress has granted to a variety of federal agencies, including the State Department. Loan guarantees, insurance schemes like mortgages backed by the federal home loan banks similarly function outside the appropriation process, notwithstanding the federal financial liability incurred. The Federal Reserve, until recently, was the only federal agency that has been given permanent, plenary authority to set its own budget without congressional oversight. This approach has been justified because of the need to have a political independent agency in charge of monetary fiscal policy. Congress effectively gives the same authority to the Consumer Financial Protection Bureau, created in 2010 by requiring the Federal Reserve to fund it. Being's recent effort to subject that agency to the usual annual appropriation process. The Statement and Accounts Clause. Article 1, Section 9, Clause 7 has a second provision which complements the requirements of appropriations and a regular statement and accounts of the receipts and the expenditures of all public money shall be published from time to time. Like the appropriation requirement, this requirement states not a power but a legislative duty that has been interpreted to require an annual budget. Such a story explains the connection between the two requirements, as well as anyone has in commentary on the Constitution in 1840. The power to control and direct the appropriations constitutes a most useful and salutary check upon profusion and extravagance, as well as upon corrupt influence of the public speculation. And to make the responsibility complete and perfect, a regular account of the receipts and expenditures is required to be published, that the people may know what money is expended, for what purposes, and by what authority. Since the founding era, Congress has largely delegated this duty under the Statement and Accounts Clause to executive branch agencies such as the Treasury Department and later the Office of Management and Budget. Those agencies in turn, and in some cases by statutory mandate, have failed to include or report in full on a variety of backdoor federal spending programs, federal insurance liability spending and borrowing by some autonomous federal entities. Certain national security spending is also excluded from the annual budget process, while the Congressional Budget Office and Government Accountability Office seek to provide a first budget accountability as the agency's legislative branch, and the Statement and Accounts Clause had de facto fallen in the purview of the executive. The two requirements discussed here are not self-enforcing and likely not judicially enforceable. They are only as good as Congress' determination to abide by them.